Hello everyone, and thank you for joining us at the Firearm Firm channel. Sorry I've been MIA for the last couple of weeks, but I'm back just in time to talk about the end of ATF's amnesty period for coming into compliance with ATF's final rule on stabilizing braces. Now, there's been a lot going on in the last week leading up to the end of ATF's amnesty period, so I want to take a moment today to make sure everyone is up to date on what's going on and that we're all on the same page. But before we get into the nuts and bolts of this video, please take a moment to hit the like button and be sure to click on that subscribe icon located down in the bottom right hand corner of this video to subscribe to the Firearm Firm channel if you haven't already done so. By now, everyone should be aware that back in January of this year, ATF published their final rule on stabilizing braces in the Federal Register. This final rule on stabilizing braces in essence makes any type of AR or AK pistol with an attached stabilizing brace into a short barrel rifle, which we all know must be registered under the National Firearms Act. In this rule, ATF gave everyone 120 days from the date the rule is published in the Federal Register to come into compliance, along with ways in which you can comply with the final rule on stabilizing braces. Feel free to check out our video on ways ATF wants you to comply by clicking on the link above or down in the description section of this video. This 120 days to come into compliance ends tonight when the clock strikes 12. Of course, once this rule is published in the Federal Register, various organizations filed lawsuits seeking to prevent this rule from going into effect. But the one that everyone needs to know about is the Mock v. Garland case out of the Northern District of Texas. In that case, the plaintiffs included two named individuals, Maximum Defense Industries and Firearm Policy Coalition, and they got a preliminary injunction against ATF to prevent them from enforcing the final rule. Now, of course, ATF appealed this decision to the United States Court of Appeals for the Fifth Circuit. The plaintiffs then asked the Fifth Circuit Court of Appeals for a preliminary injunction pending ATF's appeal, which on May 23, 2023, the Fifth granted the motion and wrote, "It is further ordered the appellant's opposed motion for preliminary injunction pending appeal is granted as to the plaintiffs in the case." The plaintiffs/appellants then sought clarification from the Fifth as to whether or not the language plaintiffs in the case in the order extended to all of Maximum Defense Industries customers and all of Firearm Policy Coalition's members. The Fifth Circuit clarified what it meant when it said plaintiffs in the case on May the 26th of 2023, writing in their order. This clarification is granted essentially for the reasons concisely set forth in the May 25th, 2023 plaintiffs' appellant's reply to their opposed motion for the clarification of injunction pending appeal. There, the appellants acknowledged that although a nationwide injunction would have functionally addressed the question of scope on which plaintiffs now seek clarity, plaintiffs understand that one was not given. Instead, plaintiffs merely request clarification on whether their reading of the term plaintiffs to include the customers and members whose interests plaintiff Maximum Defense and Firearm Policy Coalition FPC have represented since day one of this litigation is correct. That reading is correct. Also, as requested, the term plaintiffs in the case includes the individual plaintiff's resident family members. So, if you are a customer of Maximum Defense Industry, a member of Firearm Policy Coalition, or a family member that resides with the two named plaintiffs, then you are protected by this preliminary injunction. If you do not fall into one of these three categories, then the preliminary injunction does not protect you, and you are subject to ATF's final rule on stabilizing brace. One thing interesting is that in this case, the order does not appear to have a specific time period that you had to be a member of Firearm Policy Coalition to get the protection of the preliminary injunction. Therefore, you could join the organization prior to midnight and be protected. Now, I've been a member of Firearm Policy Coalition for several years, so based on the clarification order, the preliminary injunction would protect me. However, I am personally going to err on the side of caution and still remove the stabilizing brace from my Saint Edge and wait for the outcomes in the other pending lawsuits. I'm sure you're going to have questions about this video and the pending lawsuits against ATF, so be sure to leave them down in the comments section below, or you can email us your questions directly at questions@thefirearmfirm.com. Until next time, stay armed and educated.